Today I'll be talking about the notion of good faith in UK contract law and discussing the question of whether it is now time for English law to embrace the duty of good faith in the performance of all contracts. I'll begin by introducing good faith, its application outside the UK, and then describe the UK's divergence from that norm. I'll then touch on Yam Seng's impact on the doctrine of good faith and how Justice Legate's positive approach to good faith is the way forward. I'll describe a few counterpoints and touch on why the UK has been so unwilling to adjust and why that no longer need continue. Particularly, I'll look at the need for legal flexibility rather than legal certainty. And finally, I'll suggest the way forward for the good faith doctrine, ultimately detailing how it should be adopted and embraced by UK courts. So firstly, to look at what good faith is. Good faith is a presumption that parties in the contract will deal with each other honestly, fairly, and therefore with good faith. It foregrounds the transparency of both parties and seeks to take into account reasonable or honest expectations of both parties. In the case of Berkeley, Justice Morgan described good faith as an obligation to observe reasonable commercial standards of fair dealing in accordance with the parties' actions. In the case of Yam Seng, which I'll be looking at in more detail later, Justice Legate describes two main elements of the good faith principle: adherence to reasonable commercial standards and faithfulness to the agreed common purpose. These cases serve to make good faith a concept in common law. However, it is yet to be an obligatory implied term in a contract. This is a rarity, as I will now show in comparison to good faith in legal systems outside the UK. Now, unlike the UK, a vast amount of common law and civil jurisdictions imply an obligation of good faith into their contracts. For example, in France and Australia, it is implied into the performance, while in Germany it is implied into the negotiation and performance of a contract. In Germany, this is also more rigidly enforced, as while France and Australia have a general implied obligation to negotiate in good faith, Germany has it codified in section 242 of the German Civil Law Codes that there is a general obligation to execute contracts in good faith. This is very similar to the United States, whose legal system establishes an obligation of good faith through the US Uniform Commercial Code, which is explicitly and squarely based on the concept of good faith, according to Stein, which highlights the doctrine's emphatic nature in the US. Also in North America, very recently, in 2014, the Canadian Supreme Court held that there was a common law duty for good faith, demonstrative of a legal system that has recently shifted and perhaps elucidating where UK contract law should be heading next. The Dutch approach to good faith goes even further. The Dutch Civil Law Code provides that the relationship between parties to an agreement is governed as well by the principles of reasonableness and fairness. In Dutch law, this principle also extends to the pre-contractual negotiations, as a party who decides to walk away at an advanced stage can still be liable for the terms of the contract for not acting in good faith. The Dutch doctrine of good faith in the pre-contractual relationship stage is considered to be one of the most progressive amongst all civil law countries, yet serves as an interesting stark juxtaposition to English law, which emphasizes the self-interest of each negotiating party and the paramount importance of freedom of contract. This notion is ultimately why UK contract law has not followed the vast majority of its peers. And this is exactly why UK contract law's approach to good faith has been described as swimming against the tide. Lord Bingham's description in Interphoto most clearly demonstrates the current state of good faith in contract law, as he closely clarifies that English law contract includes no overriding principle of good faith. He goes on to explain that UK law differs from lots of international legal systems, however explains that the UK has characteristically committed itself to no such overriding principle, but has developed piecemeal solutions in response to demonstrated problems of unfairness. So Bingham does demonstrate here that while the UK doesn't share the same codification as other legal systems, good faith does very much exist, but rather in a more fragmented way. And as this is the case, it becomes increasingly puzzling that the UK does not piece these fragments together to create a clear codification of the good faith principle and ultimately making it contractual duty, as so many other systems do, and do successfully. However, the UK's reluctance to do this nevertheless remains, demonstrated by MSC Mediterranean Shipping, where the decision supported the notion that there are no overriding principles of good faith under English law. Their approach demonstrated the overall reluctance in decision makers who remain unconvinced by the enthusiasm of the development of good faith, something that was initially shown in regards to this case, particularly after Yam Seng. Despite this, whisperings of good faith do remain in the contract law sphere, and particularly surrounding this huge case, Yam Seng and Justice Legat's approach to it. To quickly summarize the facts of the case, both parties had entered into a contract to do with the distribution of certain fragrances across the Middle East and Asia. The claimant, who was Yam Seng, wanted damages for a breach due to certain failings to sell the products, and also for providing false information back to Yam Seng. So Yam Seng suggested that there was an implied term that the parties must deal in good faith in the agreement, and ultimately Justice Legat had to decide whether or not a duty of good faith had been implied, to which he agreed that it had been. So this was a big decision in terms of the advancement of the good faith doctrine. And Justice Legat's approach surrounding the case was a positive one, not only for the case itself, but also for the future of good faith, as he did hint that it could be implemented as an implied term. But obviously this wasn't finalized or established just by this case. So perhaps his most convincing point details that it is hard to envisage any contract which would not reasonably be understood as requiring honesty in its performance. This demonstrates why international legal systems adopt good faith, because it makes reasonable sense and reflects the core principles of entering into a contract. This reasoning reflects that of Lord Bingham in HIH Casualty, as he states that each party will assume the honesty and good faith of the other. Absent such an assumption, they would not deal. This is even further reinforced by Lord Stein, who claims that there is not a world of difference between the objective requirement of good faith and the reasonable expectations of parties. There is therefore no need for UK contract law to swim against the tide, when all it really has to do is simply stop swimming and float, because adopting a notion of good faith would be a simple change that would put an end to much speculation and controversy, and would finally clarify and answer the question of whether good faith can or cannot be enforced. However, perhaps it's not quite that simple. In Walford and Miles, Lord Acknott highlights the uncertainty that may come with widening the scope of the doctrine, as he claims that good faith is unworkable in practice, as it is inherently inconsistent with the position of a negotiating party. And Acknott is not wrong that good faith may be more difficult to control and interpret, particularly as, like he says, essentially everyone has moral inconsistencies. Brown's Sword reinforces this claim, as he writes that an imperfect translation of ethical standards could cause a distortion of personal values. However, this overall argument disregards the creativity of a jury, as Farnsworth comments later, and ultimately the breadth of a doctrine such as good faith leaves more room for such creativity. These sorts of interpretable notions are what makes a jury, and what makes it creative and gifted judges able to excel and add value to cases. If every case was decided by a one-dimensional robot, then perhaps adopting a broad doctrine would not be beneficial. However, in reality, it gives more freedom and value to the judiciary, which is beneficial for case outcomes because there is more humanity and rationality in the decision, which leads to a reduction in exploitation and opportunism. Good faith is really about injecting more potential for human reason into contract law. To quote Stein again, if it were a wholly subjective notion, one could understand the skepticism. If it were an impractical and open-ended way of fastening contractual liability onto parties, it would deserve no place in international trade. But it is none of these things. So substituting uncertainty, which isn't really even uncertainty, as demonstrated by the rest of the world, for more humanity can surely not be a bad idea. There are many other broad doctrines within contract law as well, which perhaps include even more confusion as to why good faith is treated differently. Promissory estoppel, for example, which as a doctrine continues to expand through cases such as the recent 2019 case, Kenny and Kenny. The expansion of this doctrine highlights a contradiction in the court's approaches throughout the sphere of contract law. If the courts are open to expansion in some areas, then why not in the notion of good faith, which would otherwise solve issues in areas such as promissory estoppel by cleaning up around the edges. Similarly, misrepresentation contains overlaps with good faith, as it is all based around reasonableness and the intentions of both parties. In misrepresentation, it must be proved that there is a false statement made by one party to the other that induced the representee to enter the contract. This has major overlaps with bad faith itself, yet the courts find no issue with the breadth of misrepresentation and the differences in interpretation that may present themselves. Good faith could be successfully adopted and applied in the way misrepresentation itself is, through legal flexibility. Our legal flexibility is demonstrated throughout the UK legal system. However, this falls short in most areas of UK contract law, which is extremely rigid on the whole. This is something that has been beginning to change, as aforementioned, but the adoption of good faith would seek to increase flexibility in UK contract law, which would ultimately have a beneficial outcome. Previously, many had associated legal flexibility with uncertainty and legal chaos, which would naturally induce business and corporate issues, and so competitive, potentially more ruthless business people may prefer legal certainty. However, this is largely a misunderstanding, as Barton finds, and instead the benefits of flexibility tend to be much more on the side of communication, trust, understanding, and actually stronger stability because of trustworthy relationships. There is also certainly a need for flexibility in crises and unforeseen times, which has been extremely relevant lately in the COVID-19 crisis, which has caused a massive legal troubles, certainly some of which could have been prevented or at least improvised by trustworthy relationships. With good faith and an establishment of trust, this will lead to a greater amount of flexibility, which can be beneficial in contractual chaos caused by events such as a pandemic, and allow for alternative routes to contract termination and create more room for innovative and cooperative negotiation. And so surely with more flexibility creeping into UK contract law, it's an appropriate time to adopt good faith, especially on the rebound from the pandemic. So now to demonstrate how English law should move forward concerning good faith. As I alluded to earlier, the Canadian jurisdiction is a good place to turn, especially due to the recency of their embrace of good faith. Like the UK, Canadian law has in the near past been reluctant to impose a duty of good faith, largely due to issues I have mentioned, such as disrupting business through uncertainty and jeopardizing freedom of contract, something English law is majorly afraid of. But ultimately, the Supreme Court's decision in the 2014 case Bar Sin firmly establishes that the duty of good faith applying to all contracts. The approach to good faith continues to develop, and as Stein describes, there is not a world of difference between the objective requirement of good faith and the reasonableness expectation of parties. But the Canadian implementation of good faith has worked because it creates a need for businesses and franchisers to be mindful of their conduct and their intentions, and to actively ensure that they are not misleading or acting in bad faith. To summarise then, the UK swimming against the tide concerning the doctrine of good faith is a burden on English contract law. Despite possible complications and confusion due to the broad nature of good faith, this is ultimately nothing to worry about. More range for interpretation instead gives more freedom and creativity to the decision makers, creating more legal flexibility which is necessary for the current legal climate. I therefore submit that it is now time for English law to embrace a duty of good faith in the performance of all contracts.